Welcome back to Good Law, Bad Law. And yes, I do still have a cold. And yes, my voice is still shot. So forgive me. We have a great episode today. My conversation with David Muraskin. He's an attorney with the nonprofit organization Public Justice. And we're talking about Ag-Gag laws that are specifically designed to protect the industrial agricultural industry. And we're going to focus on some of the historical cases in this area where groups like PETA, People for the Ethical Treatment of Animals, went in undercover and exposed conditions in factory poultry farms and factory cattle farming, to a case that David has been involved in, where in Wyoming they passed a law that has now been struck down thanks to David's case because of its implications to the First Amendment and the right to collect environmental data, even if that means that data is going to be used to criticize industrial ranchers and their practices out west. It's a really important issue. We have to understand how our food is produced and what the environmental implications of that are. This is an important line of cases that David has been involved in, and he does a great job of walking us through this. I know you'll enjoy this episode. And by the way, listeners, if you haven't done so already and you're enjoying this podcast, and I hope you are, please go to the place where you get your podcasts and subscribe. We're on iTunes, Stitcher, Podbean, Spotify, all the places where you get your podcasts. And please do subscribe and send us a comment as well. Stay tuned. My guest today on Good Law, Bad Law is David Muraskin. He is an attorney with the group Public Justice, and we're going to be talking today about a case that he is handling out in the state of Wyoming that is one of a number of cases that have come to be known as Ag-Gag cases. So he's going to explain what that means and what's going on in the state of Wyoming and what he does. And first of all, David, welcome, and thanks so much for being on the program.
Thanks so much for having me. Really great to talk with you.
This is a fascinating case, David, and one that I have been following in the news and generally been interested in these so-called ag-gag cases. And we're going to talk about what that is, what those cases really are about generally, and get into some of the details of the case that you are litigating out in Wyoming and the success that you've had out there, and what the implications of that might be for other cases that come along. But first, and excuse my voice, please, and listeners, please excuse my voice. I'm getting over a cold and it has ravaged my voice, but I'll do the best I can here. But tell us, David, a little bit about yourself personally, how you got interested in this and what you do for public justice, and also what public justice is and what as an organization it is the work that it does, please.
Sure, and I'll probably take those in reverse order just to kind of
Sure.
go from broadest to narrowest. Public Justice is a Washington, D.C. based national nonprofit focused on using the law to move policy issues, particularly around corporate consolidation or government abuse. And we do a variety of work in those areas, including against arbitration agreements and related to some gender and sexual violence issues. But we've always historically been very interested in environmental issues, and particularly in coal. About 5 or 6 years ago, we noticed the consolidation in the animal agriculture industry. The animal agriculture industry is actually one of the most consolidated industries in the country, even though you may not kind of hear about it. So, for instance, 85% of production of all meat in this country comes from literally 4 companies.
Wow.
That's actually about 6 years old, so it's probably yet more than that now.
Well, wait, when you say all of food production, do you mean animal food production, or are you including also, things like corn and soy and things like that?
So I'm talking just about animal agriculture, not agriculture writ large, but a lot of the corn and soy that is produced, in fact, is for animal agriculture, and so it still runs under those companies, but we focus particularly on animal agriculture, the growing of chickens, the growing of hogs, beef, things like that.
Wow.
And so I am involved in our food project. I'm a food project attorney here with two other people. There's three of us total, and we look at ways to take on consolidation in that industry and the negative effects that it has. So we look at a variety of environmental suits. We look at some administrative challenges, and we also have been increasingly focused on transparency. One of the ways in which the companies wield their power is that they try to suppress information about how food in this country is produced and keep that from the public. And so we do both consumer cases from that perspective. We have a false advertising case against Hormel, the producer of Spam, right now. And we also do a variety of First Amendment litigation to ensure that people have the opportunity to expose what's going on with these companies. And that's where the Ag-Gag work comes from.
Right. Okay. And how did you? I also always interested in the personal stories of the people we're talking to too, and I think our listeners are interested as well. Tell us a little bit about yourself and how you came to this work.
So I have a consumer and whistleblower background. I first worked at Public Citizen after clerking and then worked for a whistleblower law firm for a while. And I was really looking for an opportunity to focus on how I could try to take on one industry. You know, we're so all over the place that we sometimes don't feel like we're always having an impact. I think that, and I'm speaking just as kind of an attorney there.
Yeah.
And so the opportunity to kind of focus my energies and really become an expert in what's going on and think about different ways to take on this single form of consolidation, try to use that as an exposure for the broader anti-consumer movement that's occurring in this country, the broader environmental harms, is what attracted me to public justice. And that's really what I've been trying to build out here along with my colleagues, Jessica Culpepper and Brent Newell.
Well, say a bit more about that, David, with particular focus on the animal agriculture industry in our country. I mean, it's really pretty staggering to think that the consolidation, as you describe it, 85% or more of the entire industry, and this is a huge industry, I'm sure, is in the hands of just four companies. What, from a consumer standpoint, I mean, this could be an entire episode, I know, just on this question, but what are some of the, what are some of the leading concerns from a consumer standpoint that are implicated because of the extreme consolidation in this area?
So, from a consumer standpoint, what we're really concerned about is greenwashing and humane washing and the ways in which consolidation is being misrepresented to the consumer. So, for instance, just to give you a bit about our suit against Hormel, Hormel has a line of products called natural choice products. They advertise it as sustainable, clean, simple ingredients, and a simple product. It turns out that those products are the meat that goes into natural choice is literally the exact same meat that goes into Spam. There is absolutely no difference in how the animal is raised in terms of how it goes into natural choice and how it goes into Spam. In fact, it can be the exact same animal, different parts of the exact same animal. And we worry that consumers are being given a misimpression about the advertising and being attracted to these kind of consolidated conglomerates rather than looking to purchase true local or more humanely raised meat. And that's one of the things we've been really focused on from a consumer perspective. But this also trickles down both to workers and the environment. So one of the ways in which consolidation rears its head is that the companies talk to each other through a series of databases called things like AgriStats. And there's a series of suits, we're part of some, and other attorneys are leading others, that suggest that these AgriStat systems, are both suppressing wages for workers and also changing prices for consumers so that you're not actually getting competitive prices and workers are not getting a competitive wage from the industry. And these can be incredibly risky industries. But one of the things I think as consumers are increasingly concerned about climate change, it's less about the direct consumer purchasing that we're really concerned about than making consumers aware of what their purchasing dollars are paying for. So, for instance, a single hog farm potentially can produce as much manure as the waste of a 20,000 person city. And, a company that has, like Hormel, has hundreds, if not thousands, of hog farms. I believe that the animal waste produced in the United States was recently approximately the equivalent of 319 times the amount of all human waste produced in the United
Oh my
States.
gosh.
And when you're dealing with that kind of waste, you are talking about gross levels of contamination. And this is contamination of rivers and streams. You get the dead zones
In the
out in the
ocean.
Gulf of Mexico, which fishers are concerned about. But more importantly, or at least as importantly, it's contamination of people's drinking water. So lots of people who live around these farms are in rural communities that are not on piped drinking water. They depend on well water. And the manure from these facilities leaches into the groundwater, goes into these drinking water, and are poisoning the neighbors that are next to these facilities. And so, we try to run the gamut and look at not just what the consumer is experiencing for themselves, but also make sure that consumers can know what their dollars are going for, and that's why we're so concerned about this transparency work.
Well, and going back to the Hormel false advertising action that you're involved in, it seems like a lot of these issues are interconnected, right? I mean, as a consumer, you may make a decision to buy what you think is a natural product, not only because you may be concerned about your own health and the health of your children, that you're buying something that is more healthful if it's advertised as natural, but you may also be making a decision to purchase that product because you're sensitive to the environmental implications of a natural product as compared to one that isn't. Everything from, is the animal given hormones? And, not only the health implications of ingesting those hormones, but the health implications of those drugs getting into the environment. So, I mean, it does seem like the issue of how companies are representing their products has pretty broad implications in all of the areas that you described.
I think that's exactly right, and I would just add on that we think that one thing that consumers are purchasing when they purchase a natural product is also a product where the animals are raised in their kind of natural states or natural environs. One of the ways Hormel advertises natural choices, they have this foragers ad. So they all sit around a table, and all these people, are coming in from the woods, having foraged their berries or, squeeze their own juice. And they say, well, and this is the natural meat that's equivalent to that.
Yeah.
And in actuality, right, these pigs that you're eating, the chickens that you're eating, literally never see the light of day unless they're on a truck being transported between buildings. They're hatched inside. They spend their entire lives in an enclosed building. They have no access to pasture. And they're slaughtered in incredibly brutal conditions, all of which don't just have an effect on the animal, but have an effect on the environment, again, because this concentration produces so much waste and other kinds of excrements that they get pushed onto the community and the external world. And we as citizens are all bearing that.
Well, and that's a good segue into the Ag-Gag litigation, right? Because my first introduction into this whole area of litigation came out of those instances where an organization or an individual snuck a camera, or video into an industrial agricultural facility, whether it was a slaughterhouse or a place where chickens were being raised en masse, or one of these hog farms that you've talked about. And the really shocking revelation that came to the public because of those videos that then became public, and how that then ties in. Maybe you can obviously much better give us the background, but I think that's got a lot to do with how these ag-gag cases come about, isn't it? You can tell us how and exactly what these ag-gag cases are about from that perspective.
Yeah, of course. I think that's exactly right. The Center for Constitutional Rights has a great report that came out last year, so it's actually now a little bit out of date as we keep on trying to pursue these cases, but it does give a great background for anyone who wants to read more on this. I think it's called Ag-Gag Across America. But I think you have the exact right general story. There have been kind of three waves of Ag-Gag laws. The first were passed in the 1990s and actually weren't used that much. They were kind of went on the books, and they kind of had their effect of scaring some people, but as a result, people just didn't pursue investigations in those states, and so they kind of moved on. And then what happened in more recent years is that a investigation came out first in Idaho where an undercover investigator, exactly as you described, went in and got pictures of a farmer beating a cow for no seemingly apparent reasons, and that became public. And Idaho began working with the American Legislative Exchange Council, ALEC, to come up with a pro-big business anti-transparency bill to stop those kinds of investigations. And so what Idaho did was it criminalized those investigations. It said if you are going to try to gain access to a farm to get an image that is not sponsored by, it's not the farmer's advertising, it is your own kind of investigation, we're going to make that a crime. And journalists and others in Idaho actually were very scared of it. I believe even one journalist was prosecuted under that law in Idaho, and that led to the first Ag-Gag set of litigation.
And explain that, because we're using that term now a few times. Ag-Gag means what?
Sure, I'm sorry.
No.
Ag-Gag is the term that we use to refer to these statutes that were passed by the agriculture industry to try to suppress information about their processes. And it's a little bit hard to give a narrower definition for that because, as we'll discuss, they've changed and morphed as we've had successes trying to push back against them. So the Idaho examples, very similar to the 1990s examples, those are kind of Ag-Gag step one, which is that they just made a very kind of blunt instrument, criminal law. If you go after and if you go in and try to investigate an agricultural facility, we're going to make it a crime for you to do that. And we've had a great deal of success pushing back against those Ag-Gag step one examples. So we won in Idaho, we won in Utah, we're pursuing a similar case and beat back a motion to dismiss and now brief summary judgment in Iowa. And all of those are very similar cases about them criminalizing undercover investigations, the attempt to kind of gain access and take videos. We were helped a lot in that litigation by the Supreme Court's decision in the United States v. Alvarez, which held that lying could be a form of protected speech. So the idea when ALEC first created these statutes was, well, an investigator is never going to say they're an investigator, and so that's going to be a lie. And so we're going to make it a crime for you to not reveal your full employment history on your application and go in and take a video. And we've been helped greatly by the United States decision, the Supreme Court decision Alvarez, which said, no, that's protected speech. And so if you're going to make it a crime for someone to lie and take a video, you in fact are making it a crime for someone to lie and speak. And because these are just statutes about agricultural operations, they're going to be content-based statutes, those that get the highest level of First Amendment scrutiny. And we've successfully gotten them struck down repeatedly throughout the country, and that's been the kind of first wave of Ag-Gag litigation.
So let me understand that a little bit. So these videos, these undercover videos, are these from people who gain employment at one of these agricultural facilities, really with the idea that they're going to, do some kind of expose on the conditions, and that's what leads to their being prosecuted?
That's the general structure. I do want to clarify a few things. One is in Idaho, these also were journalists, and journalists do sometimes use similar processes, of taking videos while they're on tours, things like that. Journalists have different kind of ethical obligations than undercover investigations for groups, say, by like PETA. But they do use similar techniques, and so it also can be investigators on behalf of newspapers. But the typical process is, yes, an investigator for a group like PETA. But one thing that gets constantly misrepresented by the industry is that investigator performs all the job functions of someone doing the job. It's not that they go in and try to do anything negative to the operation. PETA ensures, and any kind of organization doing undercover investigations ensures that these people are, in fact, fulfilling the job function of the industry. They go in, they are fully trained on how to do the job function. They actually perform the jobs for the farm and in exactly the manners that they're requested, absent them breaking the law, asking to be told to break the law. And all they're doing is also wearing a camera at that time. And so what the statutes did was they said, well, if you don't reveal the fact that you're from PETA, even though you fully admitted that you will do the job and given you the background and your qualifications for the job, that is a crime.
Mm.
And because of the Alvarez decision saying that you can, in fact, make a misrepresentation that can be protected speech, and because it solely targeted these statutes at agricultural facilities, we've been able to get that struck down in a variety of states.
And we mentioned a couple of names that you mentioned. I just want to make sure we explain what those are. You mentioned PETA. That's the organization called People for the Ethical Treatment of Animals, right? PETA
That's,
has been one of those
that's exactly
activist
right.
groups that has gone in with a goal of trying to bring to light some of the conditions in these industrial agricultural operations. Um, and ALEC we mentioned a couple of times too, and I'm familiar with ALEC in a much broader context as coming from as an organization that creates model uh, statutes and then lobby state legislatures on a variety of pro-business agenda issues to try to get state legislatures to pass these laws. And in this case, as you pointed out, ALEC has been pushing these types of Ag-Gag laws as a way of protecting the agricultural businesses, and as we'll hear more of in the case in Wyoming, the ranching industry as well.
That's exactly right. I do think the last point about ALEC, the American Legislative Exchange Council, is the really important one, which is that they are a business-driven entity. They attempt to present themselves as this neutral legislative drafter, something like, the offices that Congress has just to draft legislative language. They are far from it, and they work hand in glove with organizations like the United States Chamber of Commerce
Right.
to pass legislation that is for a particular interest, and have really been working with the agricultural industry to pass these laws. And, one of the things I think is really valuable from our earlier introduction is just to underscore that when we say the agricultural industry, we do not mean the individual family farmer.
Right.
We regularly work with the individual family farmer. We are very much interested in protecting their livelihood. When we're talking about the agricultural industry, we're talking about those four companies that control 85% of the sales. And that's what we mean when they say they're working with the agricultural industry.
So just to go back and understand, because again, I think there's some precedent, if you will, in this first round of Ag-Gag cases where people are going in undercover, as you point out, doing the work of an investigator, but also doing that work with the goal of filming conditions and then being in a position to share that with the broader public. The and the Supreme Court case you mentioned that says you cannot punish somebody criminally for speech, and we're going to come to the First Amendment issues in your case in Wyoming as well, and that's why I want to lay the groundwork a little bit for that here. I mean, certainly an employer may have the right to fire somebody if they misrepresent their qualifications, but that's one thing separate from a person being criminally prosecuted for misrepresenting with the goal of creating this type of speech, right? That's the distinction that's very important in those cases.
Yeah, so that's exactly right. United States v. Alvarez was a case, it's called the Stolen Valor case, is how it's sometimes referred to in the news. Essentially, California passed a law that said you couldn't misrepresent the fact that you've been awarded certain military credentials, military awards. And a candidate for office in California did, in fact, misrepresent that he had a military award, and that went all the way up to the Supreme Court. And what the court said is that the simple fact that a statement is a misrepresentation does not bring it outside the sphere of the First Amendment's protections. The First Amendment has certain limits, as all attorneys are aware, and they typically are about things like fighting words, and things like that. Things that can cause real harm. And what the Supreme Court said in Alvarez is sometimes a misrepresentation can cause real harm. And in that circumstance, that particular type of misrepresentation could be outside the First Amendment's protections. But that the simple fact that something's a falsehood is not in and of itself make it invalid of First Amendment protections. And so what ALEC and the agricultural industry was trying to do is say the simple fact that you did not reveal the fact that you were also had this agenda of taking a image, even though you did accurately state all your credentials and did accurately perform your job and was not trying to do anything to undermine the actual business while you were there in their employ, that was a crime. And that's where we've gone in the courts to say that's too far.
Mm-hmm.
If
Okay.
you, that violates the First Amendment.
Okay. So transition us then into the rancher case in Wyoming that you've been involved in. Now that we understand a bit of the background to these cases.
Sure. And well, in Wyoming's what I would call the Ag-Gag Step 2. So we won these cases in Utah and Idaho before Wyoming really got going in its legislative process. Utah and Idaho were on the way. The writing was on the wall, although those cases obviously take a long time, and so they've just recently wrapped up in some instances. And so in Wyoming, we get Ag-Gag Step 2. The ALEC says, okay, we can't criminalize lying, so we're going to try to criminalize quote-unquote trespass.
Yeah.
So we're going to say if you are going to collect data about the environment and you accidentally touch land on the way to get that data, and it's private land, even if it's unmarked, you're going to be both civilly and criminally liable. And this, this is both a product of the fact that we won those cases in Idaho and Utah, and also the fact that Wyoming is just a little bit different than Idaho and Utah in its structure. The agricultural interests in Wyoming are about ranching, as you mentioned, and less about factory farming. And so the environmental groups are more concerned in Wyoming about getting data about how the ranching industry is impacting public lands. Large swaths of Wyoming are
and public
federally owned
also
or state-owned public lands.
And public, of course, means protected lands. That those are lands the government is setting aside for the purpose of making sure that they're not damaged environmentally, or at least that's one of the reasons.
Exactly.
Yeah.
Exactly. And, what's so funny about the way Wyoming went about this was they were just so blatant in what they were doing. So these are public lands, and as a result, the federal and state government sets conditions about what kind of data they'll consider for what's going on public land. And they specifically require that all the data be collected with the GPS coordinates of where it was collected, so that another researcher could go and look at that data, and you can look at trends over time and do modeling. It's an explicit requirement of the Wyoming Department of Environment's rules about what is credible data. And it also is actually a specific requirement of the contract the Wyoming Department of Environment entered into with the lead plaintiff in the Wyoming case, Western Watersheds Project. Western Watersheds Project is a nonprofit that does environmental reviews in Wyoming and other states throughout the Mountain West. And they got an agreement with the state of Wyoming to say that they could collect data for the state about what's going on in public lands.
So what kind of data? What kind of data are they collecting, and for what purposes?
Sure. The data it actually varies a little bit. It can be anything from a water sample to a photograph to some measurements. It depends exactly on what they're measuring. So if you're looking at whether ranching is contaminating a stream, you collect some water. If you're looking about whether lands are being quote-unquote overgrazed, which means that they're being grazed to the point that they can no longer sustain the natural fauna on there, and that you are trying to ensure that they can get the right plant growth, you take measurements and photos. Sometimes you do all three. And all of that was encompassed within the definition of data in the statute. But what Wyoming's required of Western Watersheds to do this was to take that data with the GPS coordinates. And what the statute said was you can't take data with GPS coordinates. So it wasn't actually a broad prohibition like you described of, just like it could apply to all workers or all people who are doing research. This was data that exactly mirrored the definition of environmental data for federal and state agencies that they have been using to get information from public advocacy groups up to the point where this law was passed.
And so the point of this particular type of Ag-Gag law really is to prevent the collection of this data. I mean, it would make it impossible to collect the data if you can't get to the place and can't access the specific locations where you need to collect this data.
That's exactly right. So, they couldn't criminalize lying anymore. So what they said was, in a state like Wyoming, which has these huge swaths of public land, and then even within them, they give little land leases, particularly for oil and gas. And these can be totally undeveloped parcels. And so you could be walking through literally thousands of acres of public land, and there could be this little tiny patch of private land in it that has no markings on it. And what Wyoming said was, if you're walking through all that public land to get this specific type of environmental data, nothing else, and you accidentally touch that little part of private land, even if you make all the best efforts you possibly could to avoid it, we're going to make that a crime and impose special civil liability. And the sole purpose of this was to suppress environmental advocacy in Wyoming.
Well, and one of the interesting things about this law that I think the court in Wyoming really seemed to focus on is the fact that in Wyoming they are already existing on the books trespass laws, meaning you can't enter onto somebody else's private property without permission. That would be a trespass. And there are penalties for trespass, whatever the reason would be, setting a, camping on somebody's property without permission, or uh, uh, entering your cattle to graze on somebody else's land without permission, or going in to collect samples. Could be a form of trespass. But when they passed this Ag-Gag law in Wyoming, already having a law that says you can't trespass on private land, they passed this particular law on top of that, and the penalties were even more stiff. Were even more, uh, the fines were greater. The prison term, if you were prosecuted criminally, would have you in jail for a longer stretch of time, even than if you trespass. And that seemed to be a problem for the court in how this was looked at. And tell us why that is. Why is that a particular problem?
You're really drilling down on two of the central components of the argument and decision here. The first is this, what we call the distinction between generally applicable laws and laws targeted at speech. So as you've described a couple of times, and I think every attorney's instinct is, of course the state can pass things like a trespass law or an employer rights law that restricts what employees can do on their property. Those are called generally applicable laws, and they are regularly allowed, and we were certainly not challenging those. What distinguishes that a generally applicable law from the Wyoming Ag-Gag law is that it was a law targeted at speech. One of the things that we are really proud of in this case, and one of the things that we think is an important development, is the 10th Circuit recognized when the case went up on appeal that data in this circumstance is speech. When the state defines data as the thing that you need to communicate to the state about the environment, it's the piece of information that is required to articulate your views about the environment, that is part of speech. The fact that it is the predicate to speech, you need it before you can actually articulate your views, doesn't mean it's outside of the First Amendment. In fact, it means it's protected by the First Amendment.
Wow,
the First Amendment protects all swaths of speech in the whole speech development process. And so what distinguished the Wyoming statute from the trespass statute was that it was targeted at speech. And so then the question becomes what scrutiny to apply. And what the district court did a really nice job of doing was explaining that under either form of scrutiny, intermediate scrutiny or strict scrutiny, the two levels of scrutiny that are applicable to all First Amendment cases, there's no rational basis review under the First Amendment, that the state has an obligation to come forward with evidence explaining why it needed to target speech rather than do something else. And that's, I think, what your second point about the increased penalties here demonstrates, is that the state needed to explain why it needed to target speech, impose these enhanced penalties on this form of trespass, and prohibit this form of trespass more than it does for any other form of trespass. And again, I think, in a kind of ironic twist, the state's own evidence here fully demonstrated it had no need for that. The state put forward 5 different witnesses, ranchers, who claimed they were experiencing trespass, and all of them testified that the greatest harm to their property and the most frequent trespass came from people who weren't engaged in data collection but were engaged in other things.
Right.
One rancher described squatters on his land, which it caused $20,000 to remove. Another rancher described people destroying his property, and all of them said, this isn't data collectors. These are other people. And nonetheless, the state chose to single out those engaged in speech. And that's where you get from a First Amendment protection issue to a First Amendment violation.
And the existing trespass laws, the generally applicable trespass laws, could deal with the situation of the squatter or the someone who's camping on someone's private property, these other situations. But then to target data collectors who are engaged in conduct that, frankly, the law requires in order to engage in the speech of, submitting comments or views to the government in Wyoming about the impact on the environment of these practices. Those got higher penalties, more severe punishment, and that is what causes the court to see that these laws, these special Ag-Gag laws, fail because they can't show that there's a need for that, right? The generally applicable laws could certainly do the job.
Or even if they could not do the job, it's the state's obligation to show why they could not do the job and why the state's making a distinction between the squatter and the speaker and choosing to signal out the speaker. Something we hear repeatedly from state attorneys, and we heard in Wyoming and we've heard in other cases that we're litigating that relate to Ag-Gag laws, is, the state legislature just is too busy, and we don't have a process in our state legislature of creating a real legislative history like they have in the federal government. And what the courts have consistently said is, no, if you're going to suppress speech, you need to justify it. And you can't just kind of come up with a post hoc rationale, and you certainly can't come up with throw your hands up and say, no rationale is possible here. This is on you.
Yeah.
And if you're not going to put in that effort, we're not going to just believe you that this is necessary. You need to show us why it's necessary. So I don't need to disprove to you that, my data collectors are doing little harm, or that I don't need to show that the trespass law was sufficient. You need to show that the trespass law was insufficient, and that it's particularly insufficient with those engaged in speech and no one else if you're going to engage in this conduct.
There's an interesting passage in the brief that you submitted, David, also looking at what we lawyers call the legislative history of this particular law. Some of the debates in the legislature and the comments from some of the sponsors of the legislation that give us some insight into why the law was created in the first place. Tell us about that, because I think that also bears on our understanding of what the reasons were here.
Sure. So Wyoming defaulted to this argument of that there's no legislative history that we need to develop because the legislative history that existed was so bad for them. The legislative history detailed that the lead sponsor of the statutes originally stated explicitly on the floor that he wished to suppress environmental data that was working against agricultural interests. The only witnesses they had testify in support of the law were ranching groups and ranching groups attorneys who stated that they wanted to suppress the results of the environmental reviews that were being caused by this data. So It wasn't just that they wanted to stop the data from being collected. They didn't say there was any problem with the data being collected. What they said was that we're so worried about the data being collected because the government's actually going to rely on it and limit our environmental impacts. And therefore, we're going to need to stop the speech.
Right. These researchers who are collecting data, they're not really doing any harm on the property. The harm is the data that they end up collecting, coupled with the speech that these organizations use with that data, which is perceived as going against the interests of these ranchers. So that
which is that's exactly right, and why you can't justify a statute to suppress speech, and that's why Wyoming had to default to its argument. One other thing about this legislative history I think is worth pointing out is that the case law here got a little bit messy, and I think the district court did a very nice job of cleaning it up in its final decision. So the state first tried to pass yet a more extreme version of these laws. It said you can't collect data and communicate to the government. The first version of these laws said, we're actually going to make it illegal for you to say anything to the government. And that kind of got laughed at by everyone, and the state legislature had to go back to the books. And in its first pass at the law we've been talking about, the one that prohibits trespass and data collection, the district court said, well, when the state legislature reviews its prior decision and comes to a new decision, I'm not sure I can actually look at the full course of the legislative history. Maybe I have to just kind of narrow my view and not consider the fact that they made all these statements about the desire to suppress speech earlier. But in his final decision, he backtracks from that and says there is strong evidence of animus against these speakers in the record here. And I think that's really important. When the state legislature went back, the statements on the record are by the chair of the state legislature saying, let's not say why this law is being passed because we don't want to influence the court. And if they could get away with that, that would be really scary. It would allow the state to kind of hide what it's doing and hide from the public its purpose. Mm-hmm. And it was really rewarding to see the district court say, no, in fact, having looked at all this now, having had the full summary judgment record before me, I'm going to say that the record here, in fact, does speak of animus. It's not that I'm going to just kind of narrow my lens and only look at the parts that the state has chosen to craft so I can't find animus. And that's a really important development that the final decision has in it.
So you're calling it a final decision. Tell us, where does this case stand right now in the courts? Is the litigation done, or is there an appeal pending?
So I'm actually looking. I believe today, in fact, is the last day for them to file an appeal. So my hope is that I should be saying, I guess I hope it's the final decision. Yeah. There has been no notice of appeal. Today is the last day for them to file an appeal. If there is no appeal, we'll be pursuing fees in the case immediately. And so that will be the final throes of the litigation. We haven't begun that process yet because if they do appeal, it seems like a waste of everyone's time in the interim.
Well, we always post a written description with our episodes, and this episode is going to go up after today in a few days' time. So if we see that an appeal has been filed, we'll just make a note of that so that people can follow this issue and keep up with what happens with it. How can people be in touch with you and be in touch with Public Justice if they want to keep in touch with this and follow along and also get some more information on these issues more generally, David? Sure.
So our publicjustice.net is our website. Mm-hmm. My email is dmuraskin, MURASKIN, @publicjustice.net. We have a special Ag-Gag page on our website through our food project links. And I want to encourage you to kind of go there and explore because as we've talked about Ag-Gag Phase 1 and 2, we're already litigating Ag-Gag Phase 3. After we had some success in Wyoming, the Chamber of Commerce passed laws in both North Carolina and Arkansas that were no longer specific to agriculture facilities. They now make it a crime, actually create civil penalties for any employee in any industry to collect any information and then release it to the public. And this is the case even though these states have trade secret statutes that are protecting trade secrets and have confidentiality statutes that allow employers to insist on confidentiality of certain information. This is just an anti-whistleblowing statute.
I was just going to say this is a direct blow on whistleblowers.
Right, that's exactly right. Yeah. And we think that they're passing these laws because they now realize that by targeting agriculture in the first instance, we were getting this court to say these are content-based statutes, and they're trying to make them broader and hide the fact that these are still part of the same Ag-Gag trend. And so we're litigating actively in North Carolina. We've already gone up to the Fourth Circuit once and are now back down, having prevailed before the Fourth Circuit. We're certainly looking very strongly at Arkansas. So this is going to continue to be a trend. And so, we talked about 1 and 2 on your program, but Step 3 is already out there, and I can anticipate that if we win in Step 3, we'll be doing Step 4 at some point too. So publicjustice.net, people can get more information. We'll include a link to that as well in our description. David Muraskin, thank you so much for being on Good Law, Bad Law and for sharing your expertise and background on this issue. It's fascinating. I have a daughter, Olivia, who I was telling you before the show is very interested in all things environmental, and I know was so impressed with some of the things that she saw about conditions in industrial agriculture, both in terms of the impact on the animals themselves and very importantly, the impact on the environment. And I know she shared a lot of that with me and members of our family. So
some sense, I'm dedicating this episode to her because she inspired me to be interested and concerned about this. So thank you so much for your time and for sharing your background on this with us.
Well, and that all makes me feel yet more honored to be on. So I really appreciate you having us on and having me on to talk about this. So thank you very
Terrific.
much.
Thank you so much, David.